everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0, and we are on episode 135. Spoiler alert, the motion to dismiss was denied, and we have some more filings to get through. So let's get started. We have many filings to read through, and I'm going to try to get through them as quickly as I can. This is going to be a longer video because there's many, and I want to get you guys caught up. So let's get started. First off, we're going to read the motion to dismiss. We also have a couple other orders from Judge Canoni. Then we have a notice of discovery from the Commonwealth. So they are still turning discovery over, FYI, even though they've already turned in their certificate of compliance long ago. All right, we also have a memo in support of allowing third-party culprits and also the motion in opposition to exclude Mike Easter, who is the retired FBI agent who teaches classes on investigatory best practices, and he has testified over 200 times at least, according to his website bio. So we'll get into that and a couple of other things. So like I said, we've got a lot to get to. So please hit the like button and let's get started. All right, so we are reading the memorandum of decision and order of defendant's motion to dismiss for extraordinary governmental misconduct. This is going to make us angry. I'm going to try to control my comments and my anger as we go through it, but it's hard sometimes. I was watching or started watching Melanie Little. I used to love Melanie Little show. I think this case has really gotten to her. She's gotten quite angry lately. She gets angry either like yelling, like she's yelling at the screen, but she's yelling at the people, like she's yelling at Canoni, but like she gets angry. She gets angry. And so I had to take a step back from her reading through this. So I haven't read through it all the way. So it's going to be interesting. So let's see. On June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of homicide in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death following the death of her boyfriend John O'Keefe on January 29th, 2022. The Commonwealth's theory of this case is that the defendant, while intoxicated, struck and took the life of O'Keefe while operating her vehicle in reverse and left the scene. Trial on the matter began in April of 2024 and concluded on July 1st of 2024 with a mistrial. The matter is set for retrial April 2025. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary government misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct, which we can all argue is what happened in this case. But Canoni, for some reason, corrupt Canoni turns a blind eye to all of the Commonwealth's BS, but yet, Alan Jackson breathes wrong and she wants to exclude him from the trial. So that's kind of what we're dealing with here. It's just very, very, very unfair set of circumstances or set of standards that she's holding the attorneys to. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that she's scheduled to begin soon. So the best remedy for her is a new trial, which she's already getting, so there's nothing to be done here, is basically what Canoni is saying. Because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied. Discussion. Dismissal of criminal charges with prejudice is the most severe sanction that the court can impose in a criminal case to remedy misconduct on the part of the Commonwealth. Well, we didn't think she was actually going to do it anyways, but they had to try. And they had to preserve the record, which they did, and thankfully it is on the record. All right, so the dismissal of a criminal case is a remedy of last resort because it precludes a public trial and terminates criminal proceedings. Absent egregious misconduct or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. A dismissal with prejudice for government misconduct is very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious that a new trial would not be an adequate remedy. Well, Judge Canoni, she's already suffered through one trial that she shouldn't have had to suffer through. So the prejudice has already happened. She's already had to endure false charges. She's continuously defending herself from these false charges, now going into a second trial. So, I mean, the prejudice is already long past this point, and it should have been dropped long time ago. And the the conduct here by the government, by Proctor, who 99.99999% positive planted taillight. If it wasn't him, somebody else did it because it wasn't there before the CERT team searched. So somebody planted taillight. Somebody is messing with Sally Port video. So that's all, I believe, intentional. There's too many coincidences to not be intentional. Too many instances of things disappearing that could be exculpatory for Karen. Too many inculpatory things for other individuals going missing as well. So it seems very, very much intentional, whatever they did. Any of the cover up that they contributed to, it was intentional. But Judge Canoni doesn't believe that it was, apparently. So, two parallel legal principles govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. But you're not giving her. So remember, they asked also for an evidentiary hearing. She's denied that as well. So she's saying here in this sentence, a motion to dismiss should not be allowed if the defendant can't show that it's irremediable harm to her fair trial. But you're not giving her the chance to show you that because you're not giving her the evidentiary hearing that she needs to show you that. So it's like you're putting her in between a rock and a hard place and she has no viable option to win with this judge, if you can tell. This just keeps happening to her repeatedly in the Norfolk County judicial system. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to a defendant that prevents the possibility of a fair trial. Well, we're still getting Sally Port video that is being turned over, like up until just very recently, that the defense has never seen. So how are we still getting video? And how is that not irremediable harm? Because if they had that video prior to at the first trial, they might have been able to, do something with that. Alternatively, in rare circumstances, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to the presumptive prejudice and the drastic remedy of dismissal of charges it may become an appropriate remedy. The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt. I'd say that that is probably this case, where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. I would say that if there ever was a case that that sentence represents, this is it. There's so much misconduct that it has, in fact, poisoned the entire investigation. And I guess not in Cannoni's eyes. The defendant here argues that the Commonwealth committed egregious discovery violations by destroying and/or withholding exculpatory evidence, and that a Massachusetts state trooper interfered with the jury during the first trial, warranting dismissal of the charges. As discussed below, the defendant has not demonstrated that she suffered any prejudice. Well, you haven't given her the chance because she didn't get an evidentiary hearing as a result of discovery violations, and cannot be cured by a new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless. So she's saying any kind of jury tampering allegations are totally baseless. She's the finder of fact here, and she's just saying none of that happened, even though you haven't had the opportunity to investigate that. But she's just going to say, I know for a fact it's all baseless and there was no jury tampering. Got it. She's just going to double down because I believe she has something to do with that jury tampering and yeah, getting those 3 or 4 individuals, I can't remember the exact number. At the very end of the trial, there were people whose faces clearly showed that they were disgusted by Michael Proctor and things that the Commonwealth witnesses were saying. And because of those faces and being more pro Karen Reed, or pro defense, rather, they were booted from the defense or from the jury. Either they were moved or selected randomly selected as alternate jurors, which, as we know now, the defense never saw the numbers that were in the little spinny thing that Jim pulled them from. Sorry, I got itch on my nose. And so we never saw the numbers. We never saw how many numbers were in there, if all of the jurors' numbers were in there. So we don't even know if that was fair or done properly. And I think Judge Cannoni had something to do with that. And I think Judge Cannoni had something to do this is pure speculation, I don't know, but I also think she had something to do with the jury foreman, I mean, being the person that she selected. And now we know that the jury foreman was very pro guilty verdict, so he was pushing for that. All right, so up first, the Commonwealth's discovery violations. Discovery obligations. The due process clauses of the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. Prosecutor may not withhold evidence that would tend to exculpate a defendant or reduce a penalty. What do you call the Sallyport video, Judge? I guess she doesn't know that the Sallyport would be exculpatory video. Evidence is exculpatory if it provides some significant aid to the defendant's case, whether it furnishes corroboration of the defendant's story, calls into question a material, although not indispensable element of the prosecution's version of events, or challenges the credibility of a key prosecution witness. Exculpatory material is subject to automatic disclosure. Graham versus District Attorney for Hampton District. Commonwealth's duty to disclose exculpatory evidence to criminal defendants is further reflected in the Massachusetts Rules of Criminal Procedure and Rules of Professional Conduct. See also, nope, never mind. You don't need to know that. Mandating that prosecutor make timely disclosure of all evidence that tends to negate the guilt of the accused. So anything that might negate the guilt of your defendant, you have to turn it over. Obviously, we know this. But so then why was the Sally Port now turned over? Sally Port video. This duty to disclose derives from the core responsibility of a prosecutor to administer justice fairly. Rule 14 of the Massachusetts Rules of Criminal Procedure pertains to the prosecutor's discovery obligations and the material subject to automatic discovery. The rule in effect at the time of the discovery issues here provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case and in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case. This includes any facts of any exculpatory nature and material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person, or of scientific tests or experiments, and statements of persons the party intends to call as a witness. Rule 14 further provides that when a party has provided all the discovery required by Rule 14 or a court order, it shall file with the court a certificate of compliance, which I said they've already done. Commonwealth has already done. It's stating to the best of its knowledge, after reasonable inquiry, the party has disclosed and made available all items subject to discovery. We've had at least 3 or 4 more discovery dumps from the prosecution, even after their certificate of compliance has been filed. This footnote says the Standing Advisory Committee on the Rules of Criminal Procedure recently proposed revisions of Rule 14 in response to the Supreme Judicial Court's requests for clarification on the definition of exculpatory evidence. Holy crap, that's long. And the development of a checklist of exculpatory evidence to provide guidance to practitioners. So, just recently, they updated the Rule 14 discovery rule for attorneys in Massachusetts. Judge Bev happened to be on that committee to change those rules. But she's going with old rules, apparently. I don't know. Continuing on, it says, in drafting the proposed revised rules, the committee sought to eliminate the withholding of evidence based on the prosecutor's estimated or perceived effect on the litigation. The Supreme Judicial Court adopted the proposed revisions. Thus, the new rule uses the simpler description of materials favorable to the defense in lieu of facts of an exculpatory nature. The rule creates a functional definition of 8 specific ways in which items or information can be favorable to the defense and provides non-exhaustive list of examples of items and information favorable to the defense. In addition to items and information favorable to the defense being subject to automatic discovery, investigative materials, items, and information other than exculpatory material that are relevant to the case and the possession, custody, or control of the prosecutor, the prosecuting office, or any member of the team are subject to mandatory automatic discovery under the revised rule. So it's even basically the rule has become even less um, it's more favorable to the defense. So if it was strict before regarding what you need to turn over regarding exculpatory evidence for the defense, it's even stricter now. Like it's more lenient towards the defense when you're deciding if it's exculpatory or not. That's um how you should think of that. All right, so the Canton Police Department surveillance footage. Factual background. And we have another footnote that says the following facts are taken from the parties' oral and written submissions, accompanying exhibits, and the court docket. Unless otherwise indicated, the facts stated are not in dispute. Any description of surveillance footage is based on the court's review of the footage, not the parties' descriptions. All right, let's go. On January 29th, 2022, after O'Keefe was found dead in the snow outside the Albert residence in Canton, Mass., police towed the defendant's vehicle to the Canton Police Department. There were multiple surveillance cameras in use at the CPD that captured the defendant's vehicle on a flatbed tow truck as it entered the Sallyport at approximately 5:30 p.m. There were also cameras inside the garage where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from these cameras is automatically overwritten on a regular basis. Footage from the night in question was not lost, however, because CPD Sergeant D. Giampetro followed his customary practice of downloading the recording of a hard drive in 6-hour increments. He is on the defense witness list, FYI, Sergeant G. Giampetro. I'm not sure if the prosecution is going to call him, but I have a feeling the defense will. On February 2nd, 2022, the defendant was charged with manslaughter, motor vehicle homicide, and leaving the scene of personal injury and death in Stoughton District Court. That day, the defendant filed an emergency motion for preservation of evidence pertaining to certain specific evidence in connection with the charges, which was granted. So there was, as we've talked about before, a preservation order in place. That preservation order, but it was with the Stoughton District Court because that's where she was first arraigned. The preservation order sought to preserve, among other things, all physical evidence, including present on or near the decedent, including anything present on or near the decedent at the time that his body was discovered, anything found at the alleged crime scene. The investigator in the matter, Massachusetts State Police Trooper Michael Proctor, took possession of requested CPD video of the Sallyport in February 2022, but did not turn it over to the prosecutor. So they're blaming Michael Proctor for holding on to the Sallyport video and not giving it over to prosecutors. So we already knew they were just going to use Michael Proctor as a scapegoat, especially now that he's fired. So it's going to be interesting if they call him to the stand. What do you guys think? Will they call Michael Proctor? Instead, for reasons unclear on the record, he kept the material in his case file. Do you think Michael Proctor might be mad that they're trying to use him as a scapegoat? I would hope that would infuriate him and make him want to squeal on all of the Alberts, but we shall see. On June 9th, 2022, a Norfolk County grand jury indicted the defendant on charges of homicide in the second degree, manslaughter while okay, we know the charges by now. On October 5th, 2022, this court issued an order directing the Commonwealth to provide the defense with, among other things, all crime scene photos and or videos taken. Okay, there's your language right there. You can, I mean, it's proven. They asked for video in connection with this case, including but not limited to photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview Road on January 29th and on February 4th, including the metadata associated with these photographs and videos. So even in the very beginning, they asked for the metadata and they still have not received it all these years later. Several months later, in June 2023, Proctor asked CPD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed of the tow truck on January 29th, 2022. We have a footnote here that says, it is unclear to the court why Trooper Proctor requested the footage at this time. Again, you could have called him in and had him testify at an evidentiary hearing to find out why, instead of being unclear on things. Because if you're unclear on things, you should have had an evidentiary hearing. In response, CPD gave state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutor. So again, blaming Proctor. Instead, he placed it in his case file. This footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue in dispute in this case, cannot be discerned. On February 1st, 2024, Proctor testified before a federal grand jury investigating the investigation into O'Keefe's death. And then we have a sentence or two that is redacted. 3 months later, on April 4th, ADA Adam Lally received Proctor's federal grand jury testimony. After reading Proctor's testimony, Lally asked the trooper if he was in possession of the video footage referenced therein. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February of 2022. So this is while the trial is ongoing. Proctor apparently is the reason why. And where is this fact coming from, by the way? Because this is the first time I'm hearing this, that after reading Proctor's testimony, Lally asked the trooper if he was in possession of the video footage. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February 22, but not the main driveway side exterior Sallyport footage provided to Proctor in June of 2023. So there's multiple camera angles and only some have been turned over. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with footage from the CPD main driveway showing this SUV on the flatbed. I beg to differ that he immediately turned it over because, if you recall, he tried to admit it as evidence when Buchanan was on the stand. He wasn't trying to turn it over and disclose it at that time. That was the first time that he was ambushing the defense. That was the first time that they had ever seen it. So this is a very disingenuous sentence. But yet she gives Lally the benefit of the doubt all the time, and the defense can never do anything right. None of this footage contained a view of the back of the defendant's SUV. On April 10th, 2024, Lally filed a certificate of compliance indicating that to the best of the Commonwealth's knowledge and after reasonable inquiry, it had disclosed and made available all items subject to Rule 14 or the court order, per the court order. When defense... Did I miss a footnote? I did. Here's the footnote that I missed. It is unclear to the court where the CPD main driveway footage came from. So again, it's unclear where all this other footage just keeps popping up. Evidence just magically appears in Canton. So it's unclear to Bev why we keep having more and more footage pop up. She should have an evidentiary hearing about it, but she's not going to. The CPD main driveway camera appears to show a different view than the main driveway side exterior camera. The recording from the camera remained in Trooper Proctor's file. How does she know that? Says who? She's throwing Proctor under the bus without even finding any facts. She's just like, yeah, Proctor, it's all Proctor. Proctor's the reason why you guys didn't have this video. But you didn't have an evidentiary hearing, so how do you know that? This is insane. On April 10th, wait, we read that? Okay. When defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised the issue to the court at a hearing on April 12th days before the trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated. Trial began on April 16th, with the first day of evidence on April 29th. On April 17th, Lally received footage of the Sallyport interior back wall camera from the CPD, which had been looking for continuous camera footage of the Sallyport on the relevant date. Okay. On April 23rd, Lally provided the Sallyport interior back wall footage to the defense. The images contained in this footage were inverted. State Police Sergeant Buchanan testified on June 5th and 6th. During his direct examination, Lally showed the inverted Sallyport interior back wall footage in open court. Because the video was inverted, what appeared on screen as the right side of the vehicle was in fact the left side and vice versa. The direct testimony did not alert the jury that the video was inverted. Well, yeah, see why it's a problem, Bev? This is a problem. But it's okay because on cross-examination, however, defense counsel questioned Buchanan extensively about the inverted image. So they cleared it up. So it's fine. Even though the prosecution did admit inverted video as evidence. And most likely altered, manipulated, whatever you want to call it. There were people appearing and disappearing and very, very strange things happening in that video. The CPD began a review of other video surveillance footage in an attempt to explain the inverted image and to respond to allegations that it had deliberately manipulated the recording. As part of this process, CPD Chief Rafferty reviewed surveillance footage from cameras in the hallways and the parking lot at the CPD in the early morning hours of January 29, 2022, prior to O'Keefe being discovered in the snow. The rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m. holding a phone near his face. In September 2024, Special Prosecutor Brennan joined the prosecution team. Yay! I hate Brennan. Listening to him, sniveling, whiny little, whatever, he just makes my skin crawl. Worse than Lolly ever did. I can't believe I miss Lolly. This guy is so corrupt and so disgustingly, blatantly unethical that he's so gross to watch. And I don't know how I'm gonna get through this whole trial watching him. You guys are gonna have to help me. So Brennan joined the team in September. On October 10th, he provided the rear lot cruiser footage along with other surveillance videos. So where were those videos? All of a sudden, Brennan can find them, but where was Lolly this whole time? Why were they not turned over before this? Very interesting, huh? So these are the surveillance videos from the CPD interior hallway, the church side exterior Sallyport, and the rear lot main side. On November 8th, the defense emailed Special Prosecutor Brennan requesting all raw video footage from the CPD, which shall include but is not limited to all cameras capturing the interior of the CPD and/or exterior of the CPD, including all parking areas, entrances, and exits, and garages between January 29th at 12 a.m. and January 29th at 11:59 p.m. Special Prosecutor Brennan responded that he would request that the CPD collect and produce all footage responsive to the request. Thereafter, Brennan asked all associated law enforcement to go through all files and databases to facilitate a review of any footage. During this process, Brennan came in possession of the main driveway side exterior Sallyport footage originally obtained by Proctor in June 2023 and not previously turned over to the defense. On January 28, 2025, the Commonwealth turned over the main driveway side exterior Sallyport video to the defense. As noted above, the footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage, but the quality of the recording is, as noted, poor. The defendant's arguments. The defendant argues that the Commonwealth provided an untimely disclosure within or destroyed certain CPD surveillance video in violation of Rule 14 Brady and the court's preservation order and October 5th, 2022 order on motion to compel discovery. She further contends that the timing and quality of the video footage that has been produced demonstrates that the Commonwealth sought to intentionally deprive the defendant of exculpatory evidence. According to the defendant, the Commonwealth's conduct was so egregious that dismissal is warranted. This argument is flawed in several respects. God, this woman is going to go down as one of the worst judges in history. First, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. The February 2nd, 2022 preservation order required the Commonwealth to preserve all physical evidence, including anything present on or near the decedent at the time that his body was discovered, anything found at the alleged crime scene. This order did not extend to the surveillance footage from the CPD. Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage. See Commonwealth versus Vasquez. As no physical evidence connected the defendant to the crime, the Commonwealth relied on the surveillance video to prove the defendant's identity as the shooter, characterizing evidence against the defendant as communication, surveillance, and physical evidence. The Commonwealth's evidence included numerous witnesses, including the victim and expert witnesses, as well as physical evidence, surveillance video, and photographs. Based upon witness interviews, physical evidence, and video surveillance footage, police determined that two suspects had entered the store and opened fire. Moreover, where the physical evidence described in the preservation order was further defined as including anything present on or near the decedent at the time his body was discovered and anything found at the alleged crime scene. Well, wouldn't the car? Well, no, I guess not. But you're calling it the murder weapon. So wouldn't it? I guess it doesn't fit into that category. I could have sworn there was more language in the first preservation order that did cover um, things within the investigation, which would be the weapon, the supposed weapon that took the person out, you would think would be covered. According to the order, it cannot reasonably be interpreted as including surveillance footage from the police station. She says okay, so it can't be reasonably be interpreted that you should preserve police station footage of a murder weapon that is being stored in your facility, even though you're recused, by the way, from investigating this. But okay. The October 5th, 2022 order on the motion to compel discovery also did not require the Commonwealth to produce any CPD surveillance video to the defense. That order required the prosecution to produce evidence of all crime scene photographs and or video taken in connection with this case. The CPD was not part of the crime scene, and therefore the order did compel production of the CPD videos. I think that's a mistake. I think she meant did not compel production. I don't know. This is not the end of the inquiry. However, the absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that production may still have been required under Brady and or Rule 14. The defendant contends that the prosecution should have inquired of the CPD if any footage existed and then produced all the footage. So the defense, because they asked for all footage, but didn't say, is there footage first, they did it wrong. Defendant contends that the prosecution should have inquired of the CPD if any footage existed and then produced all the footage. Oh, okay. I read that wrong. Never mind. Sorry. She's right. So the prosecution, the Commonwealth, should have gone to the Canton Police Station and said, "Give us all the video." But that's not what happened. But that is what the defendant is arguing here. But she maintains also that it contains exculpatory evidence. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence. Assuming, without deciding, that the footage is actually useful to the defense, dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory in the first trial and can do so again in the retrial. So you're so lucky to be able to use that defense again. Like, you did it the first time, you can do it again. No big deal. In addition, while the current Rule 14 makes clear that the Commonwealth is required to disclose to the defense as investigative materials video and audio recordings in the possession, custody, or control of any member of the prosecuting team, Rule 14 in effect at the relevant time had no such requirement. Nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether such evidence exists. In this regard, the Standing Advisory Committee, the one that Judge Cannoni's on, proposed a revision of Rule 14, which Supreme Judicial Court adopted. The revised Rule 14 devotes a section to the prosecutor's duties to inform and inquire, collect and disclose, preserve and notify and record items that are subject to the rules. Because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, what are you talking about, woman? They've been asking to preserve evidence. They've been asking to preserve things, and because they're not using the exact language you want, it's it's just discounted. Got it. Oh my God. Okay, I said I wasn't gonna get mad, and I'm mad. All right, let's move on. It's not clear on the record how or when the Commonwealth should have known that the surveillance videos were germane to the defense. Until the Commonwealth knew, for example, that the defense theory included the law enforcement tampered with the tail light while it was at the Sally Port, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any relevant video footage ever existed. I'm sorry, what? They should have preserved it regardless of what the defense's theory is. But she's saying that they only needed to preserve it after they knew the defense's theory after trial. That makes no sense. Cannoni is so dumb. And we have 2 footnotes. Defendant also argues that the rear lot cruiser side camera footage should have been turned over because it was exculpatory impeachment evidence that the defense could have used to show Higgins perjured himself before a federal grand jury when he testified that he did not call anyone on the night in question. The argument fails for several reasons. First, it is not all clear how, within the bounds of admissible evidence, the defendant could introduce evidence of this alleged perjury at her criminal trial. You impeach them? Second, even a cursory review of Higgins' grand jury testimony reveals that he said blank, blank, blank. Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot holding a phone near his face, does not clearly show, as the defendant represents the witness speaking to some unidentified individuals on the phone. The clip does not okay, but he has a phone to his ear, holding it like a human holds a phone to their ear when talking on the phone. But she's saying that that doesn't mean that he was actually on the phone. Got it. Finally, in this regard, the remedy for non production of the video clip is not dismissal because the defendant's rights are fully protected by her ability to use it for all it's worth at the retrial. Next footnote says, with respect to the main driveway side exterior Sallyport camera, even if Proctor should have turned it over to Lolly prior to trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. So she's saying that even though they failed to turn over discovery, it doesn't matter because the discovery wouldn't help you because you can't decipher what it is. Which I would beg to differ because if they actually had the original video and original metadata and knew that it was the original video, they might be able to see it differently. And we might be able to know that conclusively, because it is speculated that they tampered with the video footage of the car to make the taillight look like it would glow white rather than red to make it seem like it was broken. So it's hard to say because we never saw the original footage. We never saw an untampered version of this footage. So we can't know for sure. To the extent that the defendant contends that the footage could have been used to impeach Buchanan's testimony, she will have the opportunity at the retrial. So no harm, no foul. She can just try again. No big deal. This is not to say that the Commonwealth had no duty to turn over the Sallyport interior back wall footage before the first trial. Finally, she admits that there was a duty to do so. The production during trial was undoubtedly late. However, the defendant received the video more than a month before it was submitted into evidence, and because she had advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown that she was prejudiced as a result of the late disclosure. In determining the consequences of late disclosure, we ask whether the defense was materially hurt in its preparation by having to meet the unexpected evidence. Holding trial court properly denied motion to dismiss for delayed disclosure where defendant failed to show any prejudice would occur as a result. Defendant made the requisite showing of prejudice by detailing the manner in which he had been informed timely of the witnesses' statements. He would have altered his defense tactics to determine the veracity of the statements. And we have another footnote here. Moreover, during cross-examination, Jackson questioned Buchanan extensively about the video being inverted and even played a corrected version of the video that was not inverted, leaving no doubt in the minds of the jurors that the video played by the Commonwealth was not a fair and accurate depiction of what occurred inside the Sallyport. Thus, the disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting her case. So, again, no harm, no foul. Even though this hurts her so badly. But it also helps her at the same time because uh because what was I going to say? It helps her because it shows that they were tampering with the evidence, but at the same time it's very hurtful to her case because if you went into Buchanan's testimony thinking right is left and left is right, then, it makes you question reality when Jackson comes up and says, wait a minute, you see how this is backwards? This isn't how it was it? And he has to admit on the stand that no, this is not accurate, even though I said it was. So it's just so messed up. And now, and to be denied after all of this, after all of these horrific obstacles that Karen has had to overcome, like them tampering with evidence or planting evidence or withholding evidence or whatever it may be, she's had to overcome every single time. And she had to overcome a mistrial. And now she's got to overcome sitting through this whole thing over again, and it just sucks. The defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all of the footage with the metadata. There is no merit to this argument. Are you kidding me? You're supposed to have metadata with your data. What is she talking about? The defendant did not make any specific request for the original footage with metadata before the first trial or before it was overwritten. There is nothing in the version of Rule 14 then in effect or the current version that entitles the defendant to the metadata or the log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required. Okay. So we're just supposed to take the Commonwealth's word for it whenever they turn over data, and they're not required to present metadata so that the defense can verify it. It seems a little unfair to me, but okay, let's keep going. Nor has the defendant demonstrated that the metadata would have been exculpatory evidence. She offers no evidentiary support for her argument that the metadata would confirm her theory that members of the CPD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody of law enforcement and from law enforcement, and from seeing Proctor damage the taillight. A defendant who seeks relief from the loss of or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his cause. Internal quotations and citations omitted. That is, the defendant must establish a reasonable possibility that the lost or destroyed evidence was in fact exculpatory. Lastly, as to this claim, to the extent that the defendant claims to have rights based upon the Commonwealth's handling of metadata, she will have the opportunity to seek redress in the context of a retrial. So she can question the witnesses about the metadata, but she can't get the metadata. And that's okay. That's sufficient enough of a remedy, according to Bev, for all this missing data and metadata. Okay, Bev. Another thing that I kind of glossed over earlier is that even if Michael Proctor is the one that held on to the video and supposedly is the only one that committed any kind of misconduct, he's still an arm of the prosecution as law enforcement. So, regardless of whether it was Adam Lally who screwed up or Michael Proctor who screwed up or whoever, it's still part of the prosecution team. Law enforcement is still part of that, and they are on the same team. They're trying to convict the same person. So it doesn't make any sense that she's just going to blame it on Proctor, but there's no accountability for that still. Doesn't matter. Doesn't matter that it's Proctor. It doesn't matter who did it. There should be accountability for it. And the fact that she's just like, "Nah, new trial, no harm, no foul," is ridiculous. And everybody should be outraged by this. Withholding of exculpatory statement of Jennifer McCabe. Factual background. On May 7th, 2024, during the first trial, the defense produced reciprocal discovery to the Commonwealth regarding the location information of witness Jennifer McCabe's cell phone. The location data showed that on January 30th, so the day after John O'Keefe was found, McCabe went to the home of Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive at the scene on the morning of the 29th. So she went to one of the first officers who arrived on scene. She went to his home the next day. Kinda sus, don't you think? In anticipation of her trial testimony, the Commonwealth met with McCabe. Lally, ADA McLaughlin, and um, Massachusetts State Police Lieutenant Brian Tully were present. So John McCabe, Adam Lawley, Laura McLaughlin, and Brian Tully all in the same room. Tully asked McCabe why her cell phone would have been in the area of Lank's house on January 30th, 2020. That's wrong. It's January 30th, 2022. McCabe said that she was with Carrie Roberts, who was picking up her daughter at the residence, and she did not speak with Lank while she was there. The Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Tully wrote a brief report on the meeting, but it was not produced to the defense until May 29th, 2024. It's a long time. May On May 21st, 2024, Attorney Jackson cross-examined McCabe on behalf of the defense. He asked McCabe if anything significant happened on the 30th, and she explained that she went to Lank's house with Roberts to drop off Roberts' daughter, and Lank's wife came out of the house and to talk to them. Jackson questioned McCabe as to why she did not report the fact that she had met with one of the first responding officers on the case working for the Canton PD, which is conflicted off the case. He further questioned her on the length of the conversation, who else she talked to at the house, and where she was during the conversation, and if she went into the house. During cross-examination, Jackson also questioned McCabe about the details of her discussions with Lally, McLaughlin, and Tully about her trip to Lank's house. She testified that when Tully asked her if she went to Lank's house on January 30th, "At first I said no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there, and that was the extent of the conversation." On June 18th, 2024, after the defense had received Tully's report of his meeting with McCabe, Jackson raised the issue of the Commonwealth's failure to disclose McCabe's statements during the meeting prior to her testimony. During trial, the Commonwealth interviewed Jen McCabe, apparently had a full interview with her. Lieutenant Tully took a report, dated the report, and then the Commonwealth held onto the report until after she testified. The interview, the report, and the completion of the report were all done before her testimony. The court offered to allow Jackson to call McCabe back to the witness stand, and Jackson declined, stating, "No, Your Honor, that's not my," and I think the court understands that's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, "You've what?" Jackson repeated, "I've done the damage that needs to be done on Jennifer McCabe," and stated, "I don't need to call her back." Why does she feel the need to put that in here? She's such a vindictive little bitch, this Judge Canoni, corrupt Canoni. I swear to God, she must have a thing for the McAlberts or the McCabes or somebody. Like, she honestly does not like it when anyone says anything bad about Jennifer McCabe. She gets quite testy. You what? I remember that moment. Defendant's argument. The defendant argues that in violation of Brady and Rule 14, the Commonwealth withheld the May 10th, 2024 false statement given by McCabe to Tully regarding her visit to Lank's house, which the defendant claims she could have used to impeach McCabe. The version of Rule 14 then, in effect, required that the statements of persons that the party intends to call as witnesses are subject to automatic discovery. The Commonwealth, therefore, should have provided McCabe's statement to the defendant after meeting with her and certainly before her testimony. However, the defendant cannot reasonably claim that she suffered any prejudice as a result of not having McCabe's statement. On cross-examination, Jackson questioned McCabe extensively about what she had told Tully about her visit to Lank's house, why she had not disclosed such events before, and the details of her visit to the house. Moreover, Jackson expressed satisfaction with the damage that he believed he had inflicted on McCabe's credibility. What do you mean? How do you know he expressed satisfaction? He did the damage that he needed to do on her because she was not a credible witness, and he made her seem very unlikable and uncredible. But we still had a mistrial. I don't understand. When he declined the court's invitation to recall McCabe to the witness stand in this manner, Jackson undermined any newfound claim of prejudice based on the late disclosure, and once again, the remedy for a violation such as this is not dismissal, especially where, as here, the defendant's rights can be fully protected at the retrial. No harm, no foul. Remedy for discovery violations. As noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. However, even if the defendant were able to show prejudice, the appropriate remedy would not be the dismissal of the charges. Dismissal with prejudice is a remedy of last resort. Under the circumstances of this case, where there was a mistrial and the defendant now has the evidence at issue prior to the second trial, she cannot show that she suffered irremediable harm to her opportunity to obtain a fair trial. What? That's illogical. Sanctions must be remedial rather than punitive in nature, aimed at curing any prejudice caused by the violation of a discovery obligation and ensuring a fair trial. Dismissal with prejudice is too drastic a remedy if the error can be remedied and the defendant can still obtain a fair trial. Indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not dismissal of the charges. New trial ordered where a prosecutor failed to pass along defense counsel's request to federal authorities for FBI investigative reports that were later revealed to support defendant's alibi defense. A new trial warranted where a prosecutor failed to disclose complete surveillance videotape which would have supported the defendant's alibi. Dismissal appropriate where defendant was prejudiced by government's deliberate refusal to produce court-ordered discovery. This basically proves that a dismissal is warranted and not a new trial. Dismissal appropriate where a defendant was prejudiced by the government's deliberate refusal to produce court-ordered discovery. They have deliberately continued to not turn over things that were covered in a protective order that they asked for early on to preserve certain evidence. But whatever. Judge Bev can mental gymnastic her way out of anything, even video of the McAlberts actually doing the crime and putting John on the lawn. If they had that, she would still be like, no, I don't think that's enough to drop the charges. We're just going to keep going. April 1st, we got to do April 1st. Nor has the defendant shown that the Commonwealth conduct was so egregious, deliberate, and intentional that prejudice would or should be presumed. Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery which would have aided her case. Even if the defendant were able to show that the conduct at issue here on the part of the members of the prosecution team was intentional, the remedy would be a new trial with a timely disclosure of the evidence, not dismissal. And what if they don't turn it over then? There still may be video out there that we don't know. Whether an indictment should be dismissed upon the defendant's motion where the prosecution has acted improperly turns primarily on the ability of the defendant to obtain a fair trial and in light of the impropriety. In this case, defendant's rights to the disclosure of evidence pursuant to Brady and the rules of criminal procedure are fully protected because no verdict was returned at the conclusion of the first trial and a retrial is about to start. So her rights are protected because she's going into a retrial? What? She has suffered no irremediable loss of any constitutional right, and her motion for dismissal on these grounds must be denied. Massachusetts State Police interference with the jury. here we go. Here's where Judge Cannoni might be walking a tight line between judge and witness in the case. How does she know these things? How does she know Michael Proctor did these things? How does she know that the things that she's about to tell us here about jury interference? Factual background. During trial, two issues arose with jurors. The first occurred on June 14th, 2024, when one juror, Juror A, reported to the court that another juror, Juror B, had made some comments about the evidence and the defendant. Let's take a look at this footnote. It says the court has omitted identifying information about the jurors. Such information is not necessary for purposes of this decision, and of course, the full record is available for appellate review. This has been done to afford the citizens who served as jurors in this case as much privacy and peace of mind as is allowed by our law. Okay, but you could have told us a little more detail. The court called Juror B to sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense expressed concern that the comments had been one-sided and against the defense and asked the juror B be excluded. The court then inquired of Juror A. Juror A stated that Juror B had made comments to her about the defendant's facial expressions during trial. The court then questioned two other jurors from Juror A, whom Juror A said were sitting close by when Juror B made the comments. So, two other jurors had potentially heard these comments from Juror A about her saying things about her facial expressions. The court then questioned the two other jurors whom Juror A said were sitting close by when Juror B made the comments. Both jurors stated that they had not heard what Juror B said directly, but that Juror A had mentioned it to them. The court then called back Juror B, who denied making any negative comments about the defendant. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, it should also strike Juror A. The defense disagreed as to Juror A. Yeah, why strike Juror A for what? Because she told on another juror that she should have said, hey, Juror B is being inappropriate. But why are you going to strike Juror A then? The court ultimately decided to dismiss just Juror B from the jury. Juror A eventually became an alternate, I believe. Not really sure specifically, but I think they did. I think anyone who spoke up or had any kind of inclination to be, pro Karen Reed was removed or um, turned into alternates in the jury. In this instance, they couldn't not do anything about it because one of the jurors came out and said, "Hey, this juror's saying these things," so they had to act on it in this particular situation. All right, moving on. On June 25th, 2024, just before closing arguments were scheduled to take place, the court received information from court security about another issue involving Juror A. A member of the Massachusetts State Police had contacted court security and said that he received information that a juror thought to be Juror A was at one, so the first juror, Juror A, the one who told on Juror B, now they're saying Juror A was at one of the local posts for the American Legion talking about the case and that there may be a recording of her doing so. At roll call for the Dedham Police on the morning of June 25th, 2024, a number of officers confirmed that they had heard similar things about the juror. This is hearsay. This right here is hearsay. A couple of Dedham police officers heard this. That's hearsay. That is hearsay. So how this ever came in, I don't know. The court called a sidebar to discuss the new information with attorneys. Defense counsel asked for the name of the Massachusetts State Police officer who had received the information, and the court officer stated that it was Lieutenant Fanning. Fanning, who was the lead investigator in the Sandra Birchmore case. And he was also on some of those chains, those text message chains with Michael Proctor, where he was being quite inappropriate and talking about the case with I think there might have been non-law enforcement on that chain too, but I know he had like a high school text chain with all of his buddies, and then he also had his law enforcement buddies that he was texting. So I don't know. Can't remember all of them, but all right. So Fanning is a supervisor in the Norfolk County Detective Unit. During the investigation into O'Keefe's death, he was Proctor's supervisor. He was also one of the recipients of a group text circulated by Proctor that included reference to looking for nudes on the defendant's cell phone, as well as a reference to defense counsel's R word client phone. That was in the exhibit. Defense counsel represents, and for purposes of this motion, the court accepts that Fanning also interviewed some witnesses in the case. Fanning was not himself a witness at the trial. Did she talk to Fanning? Like, how does she know that Fanning interviewed witnesses? This is so wrong. All of this is just like so bizarre. None of this should be happening. There's too many incestuous relationships going on and too many things going on in Norfolk County to make any sense. She says Fanning was not himself a witness at the trial. After explaining to the attorneys the situation, the court called Juror A to sidebar. The following exchange occurred. The court says, it has been brought to my attention that you might have been out recently at an American Legion or a Knights of Columbus or someplace like that in Dedham, and that someone has reported that you may have been recorded talking about this case. That is the information I have. What can you tell me about that? Juror says, I don't know. Court says, have you been at an American Legion Hall? The juror says, like a month ago. Court says, okay. At the time, were you at all talking about? Not that I remember, no, says the juror. Court says, do you remember if people there mentioned to you anything about this case? Juror says, I was drinking, I don't remember. Court says, okay. The further information I have is that this morning, several Dedham police officers said that they heard the same thing. So basically, it's just a reiteration of what was told 4 months or 4 weeks ago, because she hasn't been to the American Legion Hall in a month. Juror says, okay. Court says, all right. Could it have happened? Juror says, I don't know. Court says, okay. Juror says, I really don't know. The court asked the juror to step aside and then discuss the matter with the attorneys. The Commonwealth expressed concern that the juror had been involved in the previous issue and requested that the juror be excused. The defense objected, arguing that the previous incident was unrelated. Focusing on the incident, the court conveyed a concern that the juror did not deny the incident, but instead stated that she had been drinking. The defense responded that the court should consider that no other juror had been affected and that the source of the information was a Massachusetts state police officer. So we're just going to take his word for it. There was no affidavit, there was no proof, there was no video, despite what they say. We never saw it. So how do we know that this is accurate? Thereafter, a discussion about Lieutenant Fanning ensued with defense counsel suggesting that Fanning and the Massachusetts State Police may be targeting potential jurors for the purpose of trying to get them excluded from the jury. Well, there you have it. Even at trial, they said that at sidebar. They thought Lieutenant Fanning might be targeting a juror to get him off the jury, which we all thought at the same time too. The court allowed defense counsel to make its argument about why the court should not dismiss the juror. ADA McLaughlin then explained to the court and to the defense counsel Lieutenant Fanning's role. Lieutenant Fanning is the commander of the extensive security operations that this case has required. What occurred is he received the information, he did not investigate, he had no evidence of any crime. If he did investigate or reached out to anyone, that could have been considered an improper influence on a jury. What he did is reported it to the chief of the trial court security to make the trial court aware, as it is simply a trial court issue. The Commonwealth then made its argument regarding why the court should dismiss Juror A. The court then conveyed its decision. I believe there is credible evidence that this juror has had conversation about this case. She did not deny it. I find that there has been a violation of the court order for failure to report it on a repeated basis. Sorry. I find that there has been a violation of the court order for failure to report it on a repeated basis. What is she talking about on a repeated basis? Juror A had no problem reporting that the other juror, but then at the time, this is poorly written. Juror A had no problem reporting the other juror, but then at the time also did not tell us that she spoke to the two other jurors I inquired of. She told us they may have overheard, and then it was another juror identified by seat number who ultimately told us that the juror had reported to her what the other juror had said. Juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror if we did hear from somebody who was at the VFW hall that night after all of this. She's putting her own like spin on it. Like, I wouldn't be surprised if this really did happen. So for all of those reasons, I am going to excuse her from sitting on this jury. At this point, a sidebar conversation continued about Lieutenant Fanning. The following exchange occurred. McLaughlin says, what I said was that Lieutenant Fanning is the unit commander of the security operations, which I know from personal, the past 3.5 months. That's his role. She knows from personal what? Attorney Liza Little said, for the jury. The court says, hold on. McLaughlin says, not for the jury, for trial support and security. The defendant's argument. A criminal defendant is entitled to a trial by an impartial jury pursuant to the Sixth Amendment to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. The defendant here argues that her Sixth Amendment and Article 12 rights have been violated by the court's dismissal of Juror A. According to the defendant, the court's dismissal of this juror was improperly based on the juror's views of the case. Specifically, the defendant contends that Juror A appeared sympathetic to the defense, and therefore the Massachusetts State Police, who have interest in the defendant being convicted, targeted the juror to get her dismissed before deliberations. And I believe that is exactly what happened. Turtle Boy was on his show last night. He went into a whole conversation about it. I'm not going to get into all of it, and I didn't want to. I mean, this is his reporting, so I didn't want to like jump in on it. But there is a gentleman by the name of Ty Donahue, Tye, I think, Ty Donahue from Massachusetts. He was a Dedham cop, one of the Dedham cops that had told Fanning that this happened. So this is the person, the leak, the whatever. He's a friend of Brian Albert's and former Dedham cop. He got into an accident while he was on sick leave. He was a patrolman for about a year. He wasn't even he wasn't even a cop for that long. He was on some sick leave, and then he had he rolled his SUV in an accident, an OUI incident. And since then, he's been doing like landscaping work. He has his own landscaping business or something. But he potentially is a friend of of Brian Alberts, and potentially is the one that reported to Fanning that this juror A was talking about the case at this VFW hall, which is unsubstantiated. There were no affidavits, no nothing to actually substantiate this. The recording of her that they supposedly had never was produced, so it's all very, very strange. The defendant also argues that the court failed to employ the proper process for dismissing the juror. These arguments have no basis in fact or in law. Okay. She's just like, nah, I disagree. Your arguments have no basis, and I say so. Woman. The defendant's first argument relies on a significant claim to clairvoyance about Juror A's sympathies at the time of the sidebar conference, and it is premised on unsubstantiated claims regarding Fanning's involvement with the jury. Have an evidentiary hearing and let's call Fanning in and find out what exactly his involvement with the jury is. And you could even call in Juror A and find out what her sympathies were in the case if you're so inclined to know if the defense is clairvoyant or not. This is ridiculous. I can't believe this isn't a court filing. Despite being specifically informed at sidebar that Fanning was not in charge of the security for the jury and without providing any evidence that Fanning ever interacted with any member of the jury, defense counsel repeatedly claims without any evidentiary support throughout their memorandum in support of the present motion that Fanning was commander of jury security and in charge of jury security. Because McLaughlin said that and had access to and control over the jury at the first trial. We've got another footnote here that says the defense argued at the hearing on the motion that it is reasonable to assume that Fanning had access to the jury because he apparently knew or became aware that the person involved in the incident at the American Legion post was a juror in the retrial. How did he know that this woman at the VFW or American Legion was speaking about this case? How would he know unless he knew that that person was a juror? How would he know unless somebody was following said juror? Maybe it was that Ty Donahue following her. Perhaps Brian Albert had people following the jurors. I'm just reporting things that I've seen on the internets. I can't confirm or deny. That is what I've seen. So, in fact, this is the very opposite of a reasonable assumption, she says. In fact, and as made clear to defense counsel at sidebar on June 25th, 2024, Fanning was the commander of security operations during the trial and not in charge of the jury. Number 11. Defense counsel submitted an incomplete transcript of the June 25th, 2024 sidebar discussions, omitting the part where ADA McLaughlin states in no uncertain terms that Lieutenant Fanning was the commander of security operations, not for the jury, but for trial support and security. Well, what does that mean? That doesn't mean that he didn't have interactions with the jury. If he is support and security for commander of security operations, he could still have interactions with the jury. That doesn't, two things can be true at once. Fanning's role at the first trial related to the significant and unusual security concerns caused by large crowds in the immediate area of the courthouse. To ensure the defendant's right to a fair trial with an impartial jury, free from outside influence, the court instituted a buffer zone around the courthouse during jury selections and throughout trial. The Massachusetts State Police and local police enforced the buffer zone. Fanning, a supervising officer assigned to the Norfolk District Attorney's Office, who has a huge conflict of interest in this case, was one of the commanding officers outside of the courthouse. The trial court is responsible for jurors. Court officers employed by the trial court, and only those officers, are in charge of the jury. The only people with access to the jury at the courthouse are the court officers of the trial court. The court officers have a sworn duty to watch over the jury. That responsibility was not and cannot be transferred to the Massachusetts State Police. Still, that doesn't mean that there was no interaction between him and the jurors. Just because you're saying the trial court officers are the only ones that are supposed to be interacting with the jury doesn't mean that people don't disobey laws. People don't commit crimes and talk to jurors even when they're not supposed to. Two things can be true at once. It can be the court officers that are in charge of the jury, and it also can be Fanning, who was somehow interfering with the jury. Calling him in for an evidentiary hearing, calling him as a witness, that would solve things. That might clear some things up. But because she refuses to do that, we're still left with, well, what? Like, what? Her answers just aren't they're not cutting it for me. Thus, counsel's claim that Fanning was in charge of the jury and was directly involved in efforts to have or one of the jurors, that's supposed to be one of the jurors, dismissed. It is, of course, required that lawyers present only good faith arguments to the court under all circumstances, but the failure of counsel to take care with the truth of their assertions in this regard has particularly damaging consequences. Oh, here we go. Now she's going to blame them for being wrong and for just spewing accusations without credible evidence when we clearly have evidence and things that could lead us to infer things in this case. This case has generated substantial public interest locally and nationally. To suggest without factual support that a Massachusetts state police officer had influence over the court and that the jury in this first trial is the jury in this first trial is to invite unwarranted public speculation and distrust about the integrity of the judicial system. Yeah, it's this reason why we don't trust the Massachusetts judicial system, because they accused a Massachusetts state police officer of interfering with a juror. That's why we don't have any trust in the system. It doesn't have anything to do with Proctor and his disgusting text messages and the way that he completely pinned it on the girl and tried to disregard, the Boston homeowner, the homeowner's a Boston cop too, all that. The close relationships that they have, the ties that Proctor and Canoni and all these people have with the witnesses. It can also be seen as an improper attempt to influence potential jurors in advance of the retrial. Get out of here, woman. Thus, the court takes the opportunity to make clear that neither Fanning nor anyone else from the Massachusetts State Police interacted with members of the jury or influenced the court's decision to dismiss Juror A in any way. When Fanning became aware of information regarding Juror A, again, you're talking about like you've spoken with Fanning and you're going to talk about or speak for Fanning. So you've obviously spoken to him and obviously you've discovered this as fact and you're putting it in a filing. This is why I'm thinking like one day she could become a witness in this. When Fanning became aware of information regarding Juror A, he turned it over to the court officer assigned to the case because it was a matter to be dealt with solely by the trial court. The defendant also argues that the court failed to employ the proper process before dismissing the juror. This argument is based on an incorrect understanding of the law with respect to the process that the court must undertake when presented with an issue as to a sitting juror. So you guys are wrong. You just misinterpreted a law. You don't understand the law. Let me teach you the law. A judge has discretionary authority to dismiss a juror at any time in the best interests of justice. When there is an indication that a juror is unable to perform his or her duties, a judge may properly discharge the juror. When a judge has reasonable concern that a sitting juror cannot comply with a court order to not discuss the case, the judge, after individual voir dire, may dismiss the juror. Judges' decisions to remove jurors after jury had been sworn was not an abuse of discretion where trial judge found that the juror had violated court orders that jurors were not to discuss the case with other jurors. When alerted that Juror A might have been talking about the case at a local American Legion post, the court explained the situation to the attorneys and then called the juror in for questioning. Juror A did not deny that this occurred, but rather stated that she did not remember and that she was drinking. The court then heard argument from counsel about what action should be taken. In deciding to dismiss the juror, the court considered Juror A's equivocal answers to questions about the incident, as well as the fact that there was a previous incident involving Juror A during which she was not entirely forthcoming about her communication with other jurors about Juror B. I wonder if this is going to bite Judge Cannoni in the butt. I think Juror A might be pissed enough reading this and coming forth, if there are inaccuracies in Judge Cannoni's um, narrative here, I would highly recommend that Juror A come forward and speak up so you can uh, show the bullshit that is going on. I mean, this is just insane. Thus, the court considered the American Legion Post incident to be a second failure by Juror A to comply with the court's order not to talk about this case. What? Based on the totality of these circumstances, the court decided in its discretion to dismiss the juror. The defendant cites several cases in support of her argument, the post-impanelment but pre-deliberation. If a judge is alerted to potential misconduct of or affecting jurors, the judge first determines whether the material raises a serious question of possible prejudice. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Based on the cited cases, the defendant argues that the court's questioning of Juror A was insufficient. The defendant, however, misunderstands the law. Again, she's got to say, you guys don't understand the law. First, the cases cited are in opposite. The primary case relied upon, Commonwealth versus Tennyson, concerns information the judge received about a claim of extraneous influence on the jury, which the co-defendant counsel raised after the jury had begun deliberations. The other cases cited by the defendant also concern the potential discharge of a deliberating juror. Finding judge improperly dismissed a deliberating juror for personal reasons. Judge who found juror repeatedly disregarded orders not to communicate about the case acted within his discretion in concluding that there was compelling reason to discharge the deliberating juror. Where's the compelling reason there? I don't see it, though, in this case. Commonwealth versus Haywood. Before a juror is excused from deliberations and replaced by an alternate juror, the judge should hold a hearing and be fully satisfied that there is a meritorious reason why a particular juror should not continue to serve. Finding judge improperly dismissed a deliberating juror for personal reasons without the appropriate procedures. Indeed, the statute which governs the dismissal or discharge of a juror draws a distinction in the process required for deliberating jurors and non-deliberating jurors. The court shall have authority to excuse and discharge a juror participating in jury deliberations after a hearing only upon a finding of an emergency or other compelling reason. While the defendant appears to recognize there is a difference between a juror who has been sworn in but is not yet deliberating and a deliberating juror, she confuses the distinction in her discussion of the law. The defendant also fails to cite an authority suggesting, as she contends, that the court was required to engage in an evidentiary hearing with Lieutenant Fanning before deciding whether to dismiss the juror. The court here called Juror A to sidebar to conduct an individual voir dire, heard argument from both defense counsel and the prosecution, and explained to counsel that the juror would be dismissed based on credible evidence that this juror had conversations about this case. The defendant was afforded all the procedural protections that she was entitled to before the court made its discretionary decision. Judge inquired of individual juror and solicited input from counsel before properly dismissing sitting juror pre-deliberation. For the foregoing reasons, the defendant's motion to dismiss for extraordinary government misconduct is denied. The defendant's alternative request for an evidentiary hearing on the matter is also denied. At the very least, she should have had an evidentiary hearing. As time ticked by and we started dealing with all these other motions in limine, we kind of could tell that she was going to deny this and not give us a hearing, or not give Karen a hearing. So, yeah, we start trial in 6 days, 5 days from now, and y- you're denied. You're denied a dismissal. You're denied a hearing, even though there is strong supporting evidence that there was a lot, not just one thing, but a lot of misconduct happening in this case. And Canoni denies it, as we all knew she would, because I didn't have any hope that she wouldn't. All right, let's move on to the memorandum of decision and order of the Commonwealth's motion for buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. So this is going to be similar to the buffer zone that they had last time, although now they've extended it because somebody said that they heard some jurors, or I'm sorry, that they heard some protesters outside, some supporters, some Karen Reed supporters. When I don't know if it's true because it was coming from the juror who was guilty voting, the foreman, and also I think it was Ronnie who said in his interview with Turtle Boy that he couldn't hear, like he could hear shouting or like muffled screaming, but he couldn't hear what they were saying and things like that. So he said that they could not hear the people outside. But because it's Canoni, she's going to side with the prosecution. Prior to the defendant's first trial on April 4th, 2024, this court issued an order establishing a buffer zone around the Norfolk Superior Courthouse, prohibiting any individual from demonstrating in any manner within 200 feet of the courthouse complex and from wearing any clothing or insignia related to the case in the courthouse during trial. So you can't wear a free Karen Reed shirt even in the courthouse. The Commonwealth now moves for the court to reestablish the buffer zone for the defendant's upcoming second trial and modify the previous order by extending it to include area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. During argument on the motion, the Commonwealth withdrew its request for second modification to the April 4th order. I don't remember what that was. To ensure the defendant's right to a fair trial, the court may restrict protected speech so long as the restrictions do not burden substantially more speech than is necessary to further the government's legitimate interests. For the same reasons that compelled the court to establish a buffer zone for the first trial, it is necessary to establish a buffer zone for the second trial to ensure the defendant's right to a fair trial. The case continues to garner significant public interest. When the matter in this court, individuals line the sidewalks outside the courthouse, loudly chanting and voicing their opinions about witnesses, attorneys, and the strength of the Commonwealth's case. They display matters which may be in evidence during trial or share their viewpoints as to the guilt or innocence of the defendant on their clothing or on signage. This is true, they do. If prospective jurors are exposed to the protesters and messages displayed on signs or otherwise, particularly before this court has had an opportunity to instruct the jurors about their obligations with regard to remaining fair and unbiased, there is a substantial risk that the defendant's right to a fair trial will be jeopardized. But you guys take them in through, like, they get bussed over from somewhere else. They all meet somewhere, get in a bus, and get bussed over to the courthouse. Then they get brought in, like, the back way. So they don't see the protesters. They don't see the people on the street. They don't see any of that. And why can't they have the buffer zone just during jury impanelment before they get sworn in, and then eliminate the buffer zone after that, so that once trial begins and everyone's sworn in and they know that they are not supposed to take any protesters or supporters uh, s- signage into consideration, then and you bring them in the back way, so they're not going to see it anyways. I think it should be fine. I don't know why they can't lift the whatchamacallit, the buffer zone after impanelment and swearing of the jury, but they don't think like that. The risk extends during trial, where jurors and witnesses would have no choice but to be exposed daily to the messages and viewpoints of the protesters when entering and leaving the courthouse or sitting in the courtroom or jury room. Additionally, the court concludes that modification to the April 4th order is necessary, despite the 200-foot buffer zone around the courthouse complex during the first trial on the western side of the courthouse complex, where there is a large open space running along High Street between Bullard Street and Ames Street. The collective voices of groups of demonstrators gathering outside the buffer zone could be clearly heard inside the courthouse. Vehicles honking their horns in response to signs and gestures from these demonstrators could also be heard frequently. Not as much as sirens. I never heard honks when we were in session watching it on video, watching it via stream. I've never heard any honks. I did hear a lot of sirens, but never honks. So I don't know. And even if people are honking their horns, so what? What does that matter? You can honk for anything. Honk for justice, honk for Hank. Like, you can honk for anything. It doesn't mean that that is proving one side or another support for either way. This is the stupidest thing. You can't honk in Massachusetts, apparently, because I guess it's just become a crime. So vehicles honking their horns and gestures from these demonstrators could also be heard frequently. Indeed, after trial, a deliberating juror reported that during deliberations, the jurors could hear protesters outside screaming and yelling. The court also recognizes the list of concerns sent to the court by the Karen Reed Trial Prepare Together group, a group of local business owners and organizations that experienced issues with protesters during the first trial. It's interesting. I don't know much about that. To ensure the fair trial with an impartial jury, extending the buffer zone is necessary to prevent jurors from outside influence and to prevent interruptions and distractions during trial. It is therefore, what I want to say too, that, like, I think they heard when it became a mistrial, when the mistrial was called, people, like, all shouted in unison outside, out of, like, relief, tension, all that, the stress building for days not having a verdict. So I think, if anything, if they heard any screams or shouts, that would have been the time that they would have heard it, was after the verdict was announced, after the mistrial was announced. It is therefore ordered that no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. The buffer zone shall further be extended to include the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. Individuals are also prohibited from using audio enhancing devices while protesting. It is further ordered that no individuals will be permitted to wear any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the trial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department issued uniforms or any police emblems in the courthouse. So, no Free Can Read t shirts, no Justice for John O'Keefe shirts, and no police uniforms. So, there's that. And this order just came in sometime this afternoon. This is the memorandum of decision and order of defendant's motion to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. Isaac L. Wolf, and requests for Daubert Lanigan hearing. So this is the latest decision from Judge Cannoni. After hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements set forth in Taubert versus Merrill Dow Pharmaceuticals and Commonwealth versus Lanigan. The proposed witness, remember, this is the guy who is the neurologist? Yeah, he's the neurosurgeon. He's the neurosurgeon. So he is going to talk about injuries to John's head and brain. So the proposed witness is qualified as an expert to testify that the head injuries sustained by the victim in this matter are consistent with falling backwards and striking his head on the frozen ground. So somehow he's a neurologist and he's an expert at the firmness of frozen ground. Dr. Wolf was the Dr. Wolf has the requisite education, training, experience, and familiarity with the subject matter of the testimony to qualify him as an expert. He is a board certified neurosurgeon with over 35 years of experience. He graduated from Yale Medical School and has held numerous faculty positions at various universities, hospitals for the last 3 decades he's been teaching. He is a founder and the medical director of the Miami Neuroscience Center. He has authored many publications in his field of expertise, including several peer-reviewed articles and numerous book chapters and journal articles related to head injuries. So she's just like singing this guy's praises. Whereas she went on and on for pages about how unqualified Dr. Russell is, but she was going to let her testify anyways, basically. And how it was such a close call. And yet, this is ridiculous. Thus, it is clear Dr. Wolf is adequately qualified to offer his expert opinion at trial. The Commonwealth has also shown that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. As noted, in addition to Dr. Wolf's many years of experience treating head injuries, he has authored numerous publications concerning, among other things, the treatment and management of brain injuries and specifically fractures of the clivus. Based on his experience and published literature, his report adequately explains the connection between the force needed to incur specific skull fractures, the skull fractures incurred by the victim in this case, and the physical consequences resulting from such injuries. Don't you need a biomechanical engineer and not a neurosurgeon? Like, how is he supposed to tell you that? Okay. Therefore, his proposed testimony that the victim's injuries were consistent with falling backward and striking his head on the frozen ground has the scientific basis and reliability necessary to be advisable or admissible to the jury. For the foregoing reasons, the defendant's motion to exclude the purported expert testimony of Commonwealth's proffered witness, Dr. Isaac L. Wolf, and request for Daubert Lanigan hearing is denied. So, not even offering them a Daubert Lanigan is ridiculous. When you're about to make the ARCA witnesses go through yet another Daubert Lanigan. You've had Richard Green come back for a Lanigan hearing. You've had Dr. Russell come back. Now she's done it twice, and She did a grueling 2-day long evidentiary hearing that had absolutely no reason to have taken place. It was basically just Hank's excuse to get answered, to get a crack at her before her testifying. It's ridiculous. And it's ridiculous that Judge Kanoe is even allowing this stuff to be taking place in her courtroom. All right, this is the latest discovery drop from the Commonwealth. So now comes the Commonwealth in the above captioned matter and indicates that as of this date, the following discovery and materials have been provided to the defendant through defense counsel. Number one, a copy of a transcript of the defendant's interview with Ted Daniels, part 2. Copy of transcript, full interview of William Reed and Janet Reed with Ted Daniels. So the first one was 44 pages. This one was 93 pages. That is uh, Karen's parents, by the way, if you do not know, Bill and Janet Reed. Ted Daniels is with Boston 25 News. He is a reporter. I don't know. I don't know what his exact title is, but he's a news guy. Copy of emails to Special Assistant District Attorney Hank Brennan. So, copy of emails. Emails to Hank. 28 pages. What are those? Voicemails to Hank. 3 audio files. What are those? People are just randomly calling and emailing Hank with supposed tips. Are these all the internet trolls that anytime you post something about Karen Reed, they all come out of the woodwork and insult you and tell you you're fat and ugly? Because that's what they do. So voicemails and emails. We've got voicemails to ADA Lally, 4 voicemails. Copy of the final report by attorney Stephen Sack, 24 pages. Don't know who that is. That file was under a protective order as well. A copy of transcript of the defendant's ID docuseries episode 1, which is 41 pages. Episode 2 is 44 pages. Episode 3 is 46. Episode 4, 47. Episode 5, 44. And then finally, a copy of an updated PowerPoint by Dr. Judson Welcher, who is 140 slides. And this is the, what is Welcher? Why can't I think of it? I think is he a biomechanic? We went through, there's been so many filings, I can't keep them straight, but we went through the filing where the defense is trying to exclude his testimony. All right, so what's up next? We've got the memorandum of law in opposition to Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. So as you know, Hank has been arguing that they should not be able to discuss third-party culprit defense, and Karen Reed's team is like, nah, we can bring this up if we want. So here comes defendant Karen Reed and respectfully request that this honorable court deny the Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. Third-party culprit evidence Ms. Reed intends to introduce at trial meets the relevant admissibility standards, and, as such, she is constitutionally entitled to present it to the jury by virtue of the Due Process Clause of the United States Constitution. Contrary to the Commonwealth's suggestion in this motion, there are no requirements that the defense name a single third-party culprit. So they have no obligation to tell you who they're going to name as a third-party culprit. Or they don't have any obligation either to prove that the alleged third-party culprit committed all of the alleged offenses exactly as charged. So it could have happened in a completely different way. Like they're claiming Karen hit him with her car, and Karen saying that he got beat up in that basement, most likely. And very different charges, very different acts, obviously. And if Ms. Reed were not entitled to introduce such evidence as part of a third party culprit defense, the proffered evidence meets the standard of admissibility for Bowden. So Bowden has to do with questioning the integrity of the police investigation. So they kind of go hand in hand too, because if the police investigation went bad, then and you didn't do it, then obviously somebody else did it. So obviously there's someone else to point your finger at that the investigators missed. So that's kind of how the two of them fit together. So they can argue both at the same time. They don't have to pick just one theory. So the proffered evidence meets the standards of admissibility for Bowden evidence and is thus admissible for purposes of establishing the inadequacy of the police investigation. Accordingly, the Commonwealth's motion must be denied. Relevant facts regarding third-party culprits. The defense has announced three potential third-party culprits in this matter. There is evidence that each of them had the motive, intent, and opportunity to commit the crime. This I don't believe has ever been in a filing. It's been argued, but I don't think it's ever been in a filing laid out this well before. It might have been, correct me if I'm wrong, but I don't think they did this last time. So all of them were present at the scene of the crime on the night in question. So first up, we got homeowner Brian Albert. Brian Albert did not have a good reputation among his fellow police officers. He was known as a bully, someone who has a history of sucker punching fellow officers, particularly when he was drinking. This is all true. He has been investigated by Boston Police Department's Internal Affairs Division for his violent conduct in that regard. Albert is a trained boxer, and several of his fellow officers were afraid of him. Brian Albert was present at the scene of John O'Keefe's death on January 29, 2022. John O'Keefe's lifeless body was found on Brian Albert's front lawn, just feet from his front door and the door to his garage. So he could have easily been brought from the house out to that lawn. Brian Albert admits to having been home at all relevant times. He never left. He was always there the whole night. He was there when John was found. So, yeah, but never considered a suspect. Evidence, including computer forensic data, overwhelmingly establishes that John O'Keefe entered Brian Albert's house. Brian Albert was drinking heavily throughout the day and night in question. Brian Albert spent the day and night with Brian Higgins. In the weeks leading up to John O'Keefe's death, Brian Higgins had demonstrated a romantic interest in Ms. Reed, Mr. O'Keefe's girlfriend, but he had been rebuffed, essentially ghosted, as they say, on this night. Higgins was confronted with Mr. O'Keefe and Ms. Reed together and clearly happy at the Waterfall Bar and Grill. Higgins' words and deeds revealed significant aggravation. And we all remember the video where he's like, oh, come here, and Chris is pulling his arm down. Brian Higgins was that was Brian Higgins, but yeah, Higgins' deeds were revealed that night. Um, so Brian Higgins was in Brian Albert's home when John O'Keefe entered. After a period of time, Brian Higgins left the Albert residence but maintained contact with Brian Albert. There were suspicious and unexplained phone calls between the two of them at 2:22 a.m. on January 29, 2022, not long after John O'Keefe was mortally attacked. Mr. O'Keefe had injuries and wounds on his right arm from an animal or dog attack. Brian Albert had a large German Shepherd at the location on the night of the attack. A German Shepherd which undisputably had a history of violent dog and human attacks in the past. So he apparently, or she, Chloe, apparently attacked other dogs and humans in the past. and two of those humans are on the list. The aggressive or the witness list for the defense, I should say. The aggressive and violent German Shepherd was, according to Brian Albert, not good with strangers. None of this evidence was investigated by the police in charge of this case. In fact, the evidence shows that was by design. Ex-trooper Michael Proctor was asked in a text exchange whether the homeowner Brian Albert would catch grief as a result of having a dead body of a police officer on his front lawn, and Michael Proctor's response demonstrated his intent to protect a fellow police officer with nope, the homeowner is a Boston cop too, verifying his intent to give a pass to Brian Albert. There is also consciousness of guilt evidence implicating Brian Albert. Despite a massive police presence on his front lawn, just feet from his bedroom window, Brian Albert never came out of the house to speak or interact with other first responders. It is worth noting that Brian Albert was at all times a first responder himself, yet he chose to ignore his duty to help someone in need in favor of remaining secure in his home away from those who might question him or his family. Could it be he had a black eye and an injured arm? Because we've seen pictures of him in a bar shortly after this incident where he has a black eye and an arm in a sling. Makes you wonder. Further, after John O'Keefe's death and after the defense publicly raised the specter of a German Shepherd attack in open court, Brian Albert's German Shepherd was quote unquote rehomed. Brian Albert essentially jettisoned a longtime member of his family to another state out of the reach of investigators, out of the reach of the defense. Any reasonable investigation would have seized upon the combination of this suspicious conduct in furtherance of a fulsome investigation into the death of John O'Keefe. What about him selling his house too? That should have been in there too. Brian Higgins. Like Brian Albert, Brian Higgins was at the scene of the crime on the night in question. Brian Higgins was at Brian Albert's house at the same time that John O'Keefe arrived and went into the house. Brian Higgins had been engaged in a flirtatious text message exchange with Ms. Reed in the weeks leading up to January 29, 2022. He has testified that Ms. Reed had kissed him after he watched an NFL playoff game with her and others not long before January 29th. He testified that Ms. Reed visited him at his apartment after that. But Higgins acknowledged that the text message flirtation and all contact between them ended and that Ms. Reed was the one to end it. She stopped responding to him. She no longer gave him any attention. This was after Higgins indicated in multiple text messages that he was not interested in her, or that he was interested in her and he found her attractive. On January 28, 2022, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe walking into a bar together, getting along, and, in the words of at least one witness, acting lovey-dovey. Ms. Reed and Mr. O'Keefe were affectionate with each other that night. Brian Higgins was there with Brian Albert watching it. Higgins' annoyance and irritation were reflected in a sarcastic text he sent to her while she and John were merely just feet away. The text said, well. There is evidence that Mr. Higgins wanted to lure Mr. O'Keefe to the Albert residence. At the waterfall, minutes before he leaves, Higgins motions to Mr. O'Keefe, then follows up with a text message to make sure that he will be going there. Because he said, what, you coming here? Higgins went inside Brian Albert's home. John O'Keefe also went inside. There is evidence, therefore, that Higgins had the motive, intent, and opportunity to cause harm to John O'Keefe. Like with Brian Albert, there is also evidence of Higgins' consciousness of guilt. For example, after a long day of drinking and driving, Higgins did not go home after he left the Albert residence that night. Instead, he went to the Canton police station. He initially claimed that he went there to do some administrative work, but later changed the story to going there to move his vehicle. He was consistent, however, about the fact that he never called anyone on the phone while there. That turned out to be false. Video evidence undisclosed during undisclosed to the defense during the first trial, establishes that Higgins made a phone call while he was at the Canton police station at 1:40 a.m. He has not revealed who he called. So who was he on the phone with? Given that the evidence was not timely disclosed, the defense did not have the opportunity to confront Higgins about that fact. When Higgins went home after that, he still did not go to sleep right away. At 2:22 a.m., he speaks by phone with Brian Albert. He tried to claim that the phone records reflect a butt dial and apparently a butt answer, which is even more ridiculous, taking Albert and Higgins' testimony together. This 22-second phone call, however, is further evidence of consciousness of guilt. Denying the phone call is consciousness of guilt for sure. This is probably the, hey, we're ready to move the body. Come on, phone call. Come on over. That's what I think that was. I think he had to go back to 34 Fairview Road to move the body outside, perhaps. When Higgins realized that the defense was interested in seeing the contents of his phone, a defense motion had been filed. He further demonstrated consciousness of guilt by getting rid of his phone and his SIM card. Brian Albert got rid of his phone too, and his house and his dog. All the things he got rid of. The manner in which he disposed of it, however, was extraordinary and showed how intent he was on keeping the information from his phone out of the hands of the defense. He destroyed the SIM card, then traveled to a military base to put that tiny object, about the size of a thumbnail, into a large dumpster. Higgins' conduct on the night in question and following that established clear evidence that should have been investigated during the course of the investigation, but which evidence was ignored by Michael Proctor and his supervisors. Finally, Colin Albert. Colin Albert, or Colin Albert, had been in a feud with John O'Keefe in the weeks and months leading up to January 29th, 2022. Colin had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off to his face. Colin Albert testified under oath that he had never been in a fight in his life, yet there was video evidence of him taunting others to fight, desperate for violence. And Turtle Boy, after the trial, called for people to send him videos of Colin fighting. There are fights out there of Colin, like videos of him fighting. He's not good, but they're out there. Colin Albert, after John O'Keefe's death, was photographed with his knuckles scraped, consistent with injuries that would be suffered during a physical altercation, especially when you're punching something or someone. Colin Albert's name was purposely omitted from the police reports. There was no indication in any of the reports provided to the defense in the first months of this investigation that Colin Albert was anywhere near 34 Fairview Road, his uncle's house, on January 29th, 2022. In fact, there was no indication in those police reports that Colin Albert even existed. It was not until the defense sent a letter to the prosecution while the case was pending before a grand jury notifying the Commonwealth that Colin Albert should be called as a witness that the Commonwealth finally produced information that Colin Albert was indeed present at Brian Albert's home on the night in question. It is a reasonable inference from the evidence finally, and perhaps grudgingly, provided to the defense that Colin Albert's name was intentionally omitted from the police reports in order to protect him. He also um, wasn't questioned until well over a year later. Almost it was like 18 months later or something like that. Similarly, Brian Albert is the only person listed in the initial report whose first name was not spelled out. He was just listed as B. Albert, and the number of his house is misstated on various first responder reports. So it seems like they're trying to hide Brian Albert's identity. These myriad mistakes are more than simply curious, they are systemic in the investigation. There appeared to be a conscious effort of the investigators of this case to hide these third party culprits from the defense and the public. And now I gotta shrink it. Okay. Here's the argument. The defense is entitled to raise a third party culprit defense. The Commonwealth's suggestion that the defense has the burden to name a single person for purposes of a third party culprit defense is incorrect and misstates the law. Likewise, the Commonwealth's claim that the defense must prove that another individual had the motive, intent, and opportunity to commit not only the crime but vehicular manslaughter and leaving the scene is also incorrect and unsupported by case law. Third party culprit evidence is a time honored method of defending against a criminal charge. A defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. They don't have to say they committed it the same way that the state is charging Karen. Defendants have a fundamental due process right to present such third party culprit evidence, and accordingly are given wide latitude to the admission of relevant evidence that a person other than the defendant may have committed the crime charged. If the evidence is of substantial probative value and will not tend to prejudice or confuse, all doubt should be resolved in favor of admissibility. Of course, while defendants are entitled to wide latitude in introducing third party culprit evidence, there are some constraints on what evidence can be introduced. Most fundamentally, the evidence must be relevant. That is, it must have a rational tendency to prove the issue raised by the defense and cannot be too remote or speculative. Still, the bar for admissibility is generally low, and again, all doubts should be resolved in favor of admissibility. Defendant permitted to introduce evidence that alleged third-party culprit had a loud argument with the victim the morning before the homicide at campground where the victim's body was found. Error for trial judge to exclude evidence that alleged third-party culprit was the victim's landlord, possessed a key to her home, and had recently opened the lingerie drawer in her bedroom. Yuck. Cases in which courts find that such evidence should be excluded, including the cases that the Commonwealth cites in its motion, the Commonwealth versus whatever, involve evidence that is relevant, very minimally probative, purely speculative, or some combination thereof, and are therefore unlike the instant case. Affirming exclusion of evidence regarding alleged third party culprit, a hypothetical rival drug dealer, where third party was hypothetical and where only evidence connecting them to the homicide was drugs found in the victim's car and in the victim's clothing. Affirming exclusion of evidence regarding alleged third party culprits, rival gang members who lived near shooting and were involved in feud with victims where no other evidence suggested they were nearby at time of shooting or otherwise involved. Affirming exclusion of evidence that alleged third party culprit had. Oh, it cuts off there. That's all we have of that. So that is all we have of that. But it gives us a good idea of what they're arguing and trying to get. Sorry, that's just where it cut off. I checked multiple sources and I didn't have any more than the 8 pages available. So that is the defense's memo of law regarding third-party culprit admissibility. I think Judge Cannoni is going to allow this in. She let it in the last time. She was pretty lenient with it. I don't think she's going to really stop it this time. But we'll see because she's Bev and she does what she wants. All right, moving on to the next filing, which is the defendant's memorandum in opposition of the Commonwealth's motion in limine to exclude Michael Easter's testimony. Now comes the defendant, Karen Reed, and files the defendant's memorandum in opposition of the Commonwealth's motion in limine to exclude defense expert Michael Easter's testimony. The proffered expert testimony of Michael Easter is plainly admissible under Massachusetts standards for expert testimony and is relevant and admissible in furtherance of Ms. Reed's Bowdoin defense. The investigation conducted by the Canton Police Department and the Massachusetts State Police was deficient and failed to conform with standard investigative policies and procedures. And it's their job to demonstrate that to the jury, to show that, if the Commonwealth is putting on the investigation of the police and the defense is saying it was not a sufficient investigation, they need to be able to demonstrate that somehow to the jury. And what better way to do that than with an expert who can speak to that? The defendant, therefore, has a right to present the expert testimony of Michael Easter, a retired and decorated agent with the Federal Bureau of Investigations, to testify regarding standard investigative policies and protocols and law enforcement's failure to adhere to those policies and protocols in this case. Here is the argument. Massachusetts case law supports a defendant's right to call law enforcement experts in investigative procedures to advance a Bowdoin defense. Remember, Judge Cannone was like, give me some case law on having someone, having an expert testify to the integrity of the investigation. So this is their attempt at showing her that there is precedented case law to do this. The Supreme Judicial Court has made clear that a defendant may introduce evidence that the police investigation was inadequate or unreliable. Pursuant to a Bowdoin defense, a defendant may introduce evidence regarding the police investigation in order to create an inference that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific tests or to pursue leads that a reasonable police investigation would have conducted or investigated, and these tests or investigation may have led to significant evidence of the defendant's guilt or innocence. I think one of the biggest things is that the crime scene was not secured, and it went hours without anyone from law enforcement watching it. And anyone from that house could have come out and dropped some shoes, some glass, some taillight pieces, whatever. Because if you do recall, there were pieces of glass and taillight that didn't match her taillight. So, or the glass that was John's, or the glass from the alleged glass that came from the bar. So we don't know, but we don't even know that it was the glass that came from the bar because they did no testing. So those are all the things that are going to come into question, I think, with the scientific testing, the no chain of custody when it came to, the swabs. We have no idea. Michael Proctor says he took the swabs of John's shirt, but he could have very well have taken a piece of ham out of the fridge and swabbed it, you know? Oh, we don't know where those swabs came from, the chain of custody. There were no videos taken of all these things are going to be questioned. And I really hope that they do because people who, know that we're familiar with true crime and watch this stuff and we're familiar with what is and isn't normal. Not everybody understands that using a snow or a leaf blower isn't normal. Those are all things that really need to be spelled out, I think. And the fact that once one thing is questionable, all of the other things along with it kind of go out the window. If one thing in the investigation is questionable, then everything else related to that one thing needs to be thrown out or taken with that grain of salt. So I think that's going to help the jury tremendously if they have this information. Indeed, a defendant has the right to base their defense on the failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt. In Commonwealth versus Bowdoin, so the original case that they're citing, the case law that became the Bowdoin defense. So in Commonwealth versus Bowdoin, the Supreme Judicial Court held that a judge's instruction for the jury to ignore testimony about the non-existence of certain tests and other evidence when deliberating constituted reversible error. The fact that certain tests were not conducted or certain police procedures not followed could raise a reasonable doubt as to the defendant's guilt in the minds of the jurors. The judge should not have removed this evidence from the jury's consideration and, in doing so, invaded the province of the jury to decide what inferences to draw from certain evidence. Basically, the judge took it upon themselves to decide what was relevant or what was not, what was what was relevant for a juror to decide something. Although the defense in Bowden itself focused on the alleged failure of the police to conduct tests or follow regular investigatory procedures, Bowden defense is not limited to these issues. While Massachusetts courts have not been specifically presented with a challenge by a Commonwealth or a defendant regarding a defendant's right to present an expert on deviations from standard police policies and procedures in the Bowden context, courts have generally recognized let me repeat that, courts have generally recognized a defendant's right to present this type of evidence and have taken no issue with the defendant calling an expert to challenge the adequacy of a forensic investigation. For example, in Commonwealth versus Wood, the Supreme Judicial Court denied the defendant's request to set aside the verdict on the grounds that he was precluded from admitting evidence that law enforcement failed to investigate a third-party culprit where there was no evidence suggesting that the third party was in any way involved. In doing so, however, the court reasoned that the issue of inadequate investigation was fairly before the jury because defense counsel was permitted to extensively cross-examine an officer about his investigation, argue in closing that the investigation was adequate, and three, through the calling of its own expert, extensively challenge the adequacy of the forensic investigation conducted by the police. Thus, the Supreme Judicial Court acknowledged a defendant's right to call an expert to challenge the adequacy of a forensic investigation. The issue presented here, calling an expert to testify regarding law enforcement's failure to conform with standard investigative policies and procedures, is no different and must also be admissible. In Commonwealth versus Dyer, a defendant claimed ineffective assistance of counsel based on the counsel's failure to hire a forensic expert to testify regarding the crime scene investigators' failure to investigate certain gunpowder residue patterns and conduct additional chemical testing of gunshot powder discharge. In that case, the Supreme Judicial Court held that trial counsel's failure to present an expert to testify about these investigative failures was not manifestly unreasonable because the proposed expert's affidavit failed to establish that the investigation and testing were reasonably necessary or appropriate for the police to conduct in order to investigate the shootings properly, such that the failure to conduct them might create a reasonable doubt about defendant's guilt. Indeed, under the rationale articulated by the Supreme Judicial Court in Dyer, expert testimony regarding law enforcement's failure to follow certain standard protocols or procedures or to engage in necessary or appropriate testing is not only admissible, it would be ineffective for counsel not to present this evidence. So that's a good argument too. Like, it's our duty to present this evidence. Should it be admitted? It is part of our role to vigorously and thoroughly defend our client. Similarly, in Commonwealth versus Reynolds, the defendant sought to call a non-expert police officer to testify in support of his Bowden defense. While the proposed witness Reynolds was not an expert, the court agreed with the defendant that he should have been allowed to call Dewan as a witness to show that the police investigation was deficient. The court goes on to assert the defendant should not have been precluded from eliciting evidence on the question simply because the Commonwealth asserted that the investigation was inadequate. In other words, the defense should not be forced to accept the testimony of the Commonwealth witnesses regarding standard policies and procedures and whether they adhere to those policies and procedures, and instead must be able to present evidence in its case in chief to establish that the investigation was deficient. So it's not good enough to just pick holes at the investigators during their cross examination. They have to do it in their case in chief, meaning when the defense puts on their case, they have to establish through their witnesses that the investigation was deficient. Under the Massachusetts Rules of Evidence and relevant case law, where an expert is not testifying on scientific, technical, or medical matters, the Daubert-Lanigan standard and general acceptance test are not required. Rather, courts are encouraged to exercise discretion as to whether particular testimony would help the jury understand information that is not within their common knowledge and to determine that the testimony presented is reliable. So technically, he's not testifying on a scientific matter or a medical matter. So he doesn't need to go through that Daubert-Lanigan hearing is what they're saying, which is awesome. I did not know this. This is cool. That's a good argument here that hopefully doesn't go over Cannoni's head. For soft sciences and other non scientific, non technical, and non medical testimony, the court has broad discretion to determine testimonial reliability and may turn to Daubert Lanigan for guidance, but may ultimately decide which factors might be applicable. Under this form of expert qualification and reliability assessment, police officers routinely testify as experts in Massachusetts. Police regularly testify about the nature of drug transactions, drug use, and gang dynamics, right? I mean, if they can testify, if officers of the law can testify as experts for the Commonwealth, why can't they testify as experts for the defense as well without having to do a Daubert Lanigan hearing? So they testify on drug transactions, drug use, and gang dynamics, information that may be in the general knowledge of a juror, but for which specialized knowledge would be helpful. So it might be something that people would know, like you and I are true crime junkies, and we know that using a leaf blower is not the appropriate way, and they should have probably put up a tent and sectioned it off and did all these other things and watched it and all these things that we know that they should have done that they didn't do, and heaters and whatnot. They didn't do any of that. And someone who doesn't watch true crime stuff and doesn't know these things, they're not going to have that knowledge. And that's what this expert is for. And for those people in the jury who are not quite sure, doesn't quite sound right that they left the scene unattended for 8 hours or whatever it was. Um, those people that just aren't quite sure, this helps connect that dot for them to say, hey, it was improper that they left it unattended. This is the expert that's going to provide the context that those jurors who don't have that information need. Here's a footnote that says, even in cases where the subject matter may be within the knowledge or common experience of the trier of fact, expert testimony will be admissible if, in the judge's discretion, it may be of assistance. All right. Admitting testimony about how drug transactions occur and indicia of possession of personal use as opposed to distribution. Holding that an officer with 18 months of training 6 months prior was qualified as an expert of administration of narcotics. So someone with 18 months of work experience and 6 months of training prior to that, they were considered an expert of narcotics because that's their job. So they're an expert. All right, so when police testify as experts, one of the court's primary concerns is blurring the line between specific testimony as a lay witness and more general testimony as an expert. Commonwealth versus Tanner. It is easy for the line between specific observations and expert generalizations to become blurred in these situations. For this reason, when possible, the practice should best be avoided. Here, Mr. Easter is an expert in investigative procedure. So, the exact thing that they are asking him to testify to. He is a decorated agent with the Federal Bureau of Investigations and is qualified by years of experience, well beyond the experience of the experts in the Commonwealth versus Little, which is the law that they were referencing down here. And his testimony about proper police procedure and investigation would surely aid laypersons of the jury in determining whether the investigation here was deficient. Given that he is only an expert witness, there would be no concern of blurring the line between his general testimony as an expert and specific testimony based on his investigation. Next point is Massachusetts Rule of Evidence 702 and Federal Rule of Evidence 702 are nearly identical and thus federal law is instructive. But for one clause included in the Federal Rule of Evidence 702 that is not included in the Massachusetts Rule of Evidence, a plain reading of which makes the federal rule appear more restrictive than the Massachusetts rule, the rules are identical to one another. So we have here Rule 2 and here. So here's the federal, here's the Massachusetts. We've got this footnote here that says the differences here, but as you can see, there is some language that looks a little different, but for the most part, it's quite similar. Let's read it. All right, so the Massachusetts Rule of Evidence 702. A witness who is qualified as an expert by knowledge, skill, experience, training, and education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine that a fact in issue, that the testimony is based on sufficient facts or data, that the testimony is the product of reliable principles and methods, and that the expert has reliably applied the principles and methods to the facts of the case. And here's the federal rule. A witness who is qualified, same language. Um, so it's basically just the top part. This first sentence is in question here. So instead of the intro, like it said there, I don't know why I did that. Uh, Here's the big difference. So it says a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that all these things were to take place. So the judge can decide. It's the judge's discretion. Therefore, federal guidance on construction of Rule 702 is especially useful and persuasive. In numerous instances under the Federal Rule of Evidence 702, law enforcement witnesses have been deemed experts in investigation and procedure. I was going to say something. I know. When it comes to when there's a law that's a federal law versus a state law, the federal law takes precedent. So if there were a state law that was unconstitutional and the federal law trumps that, then it makes it would make that other law not legal technically. All right. So in the United States versus Polson, the United States District Court for the Southern District of Ohio held that the defense may introduce expert testimony by a former FBI agent on the adequacy of the government's investigation. Polson held that expert testimony need not always be premised on scientific principles and experience-based testimony satisfies reliability standards. So it's not just scientific principles that allow someone to be an expert, but also your work experience can allow you to be an expert. your experience in a certain field. Disagreeing with the government's argument that the testimony will not assist the jury in resolving any fact issue and therefore should be excluded is absolutely irrelevant. I added the absolutely. The court found that evidence tending to show inadequacies in the investigation would be probative of whether the government has made its case against defendants, as would an expert's testimony on such matters. Further, the fact that the defendant could have attacked the investigation solely through cross examination did not preclude the defendant from introducing expert testimony on the issue. Um, True. Defendants can attack the government's investigation through effective cross examination of the government's law enforcement witnesses, but just because defendants can achieve their objectives in one way, cross examination of the government's witnesses does not mean that they should be precluded from pursuing that objective in other ways as well, like putting on their own witnesses. So, this is like exactly word for word what is kind of happening here. They're trying to the Commonwealth is trying to exclude witnesses for the defense that they want to put on, and they have every right to do so. And like they're saying, cross examination of the government's witnesses is not necessarily the most effective remedy. You might want to bring your own witnesses on. Because the Commonwealth's witnesses aren't going to be like, yeah, we really botched that investigation, you know? They're not going to say that. They're going to double down and say, yeah, we did the best we could. In Thomas versus Lambert, a former Michigan State Police officer who also worked in the Air Force Office of Special Investigations and founded and ran an investigative group, was deemed an expert in proper techniques and reasonability of police investigation. So he's a former Michigan State Police officer who worked in his own private investigative firm or whatever, and he's was deemed a proper expert for investigative purposes. The court further noted that specificity of expertise should primarily go to weight rather than admissibility. Another expert in Thomas, who was a police chief in Florida, had graduated from the FBI Academy and was pursuing a doctorate in criminal justice, was qualified to testify about investigative techniques, even though he was not an officer in the jurisdiction of the case. Both of the experts' opinions in Thomas were based on sufficient facts and data to meet the bar for reliability. Specifically, they compared actual police practices to model policy papers, the Michigan State Police's official orders, and their extensive investigative experience. Further, the experts in Thomas were called to comment on the reasonability and scope of searches and seizures in the 1983 action. Even though opinions on reasonableness struck close to the ultimate issue in such cases, testimony about reasonableness was admissible. Here, Michael Easter's proffered expert testimony clearly satisfies all of the elements set forth in Evidence Code Section 702. Indeed, his specialized knowledge will assist the jury in understanding, among other things, law enforcement's failure to follow standard policies and protocols regarding crime scene management, chain of custody, and handling of evidence. So these are all the things he's testifying to. Let me back up. Standards, policies, and protocols regarding the crime scene management, chain of custody, and handling of evidence. So, what happened in that Sally Port video? Managing a chronological record were the logs for those Sally Port videos, and timely and accurate reporting in connection with this investigation. Law enforcement's failures in this case are well documented and in violation of the stated policies and procedures set forth in the Massachusetts State Police Policy and Procedure Guide. His proffered testimony is the product of reliable principles and methods which are based on his years of experience as a decorated agent with the Federal Bureau of Investigations and the stated policies of the Massachusetts State Police. Finally, his opinions reflect a reliable application of the facts of this case, namely information obtained directly from the Commonwealth and the police reports and logs associated with this case, and the stated policies of the Massachusetts State Police. Thus, like the expert in Polson, Mr. Easter would use his years of experience to testify to standard investigative practices and law enforcement's failures to adhere to these protocols and procedures. Here, Mr. Easter's testimony does not reach the ultimate issue, Ms. Reed's innocence or guilt. Rather, Mr. Easter would opine as to whether the investigative procedures employed by the Massachusetts State Police were in line with the stated procedures of the department and general best practices. Yeah, so why are they so afraid? If you guys followed policy and procedure, why are you so afraid of being called out? Because they know they didn't. Finally, the Commonwealth's suggestion that any examination or evaluation of police procedures and protocols would be speculative is belied by Michael Easter's report, which repeatedly references the policies set forth in the Massachusetts State Police Policy and Procedure Guide. So he's not just randomly speculating on what is believed to be proper protocol. He's reviewed the Massachusetts State Policy and Procedures Guide and knows definitively this would not be proper. It's not speculative at all. So while there may be variation between different officers' investigation styles, all law enforcement agencies have standards to ensure competent, adequate, and ethical investigations. This the suggestion that any assessment of the investigation would simply be a subjective opinion as opposed to an objective analysis based on professional standards and best practices is insulting to officers that spend years developing expertise in the area of investigation. So, just the fact that the Commonwealth, Hank, said that this is a subjective opinion and this is speculative in nature, that's very insulting to people who have dedicated their whole lives to law enforcement because there's standards, protocol, there's things you need to follow, rules you're supposed to follow. And it doesn't seem like it in Canton, but there are. They don't get followed in Canton. The Commonwealth's authority regarding second guessing law enforcement officers is in opposite. The Commonwealth cites two cases to suggest that expert testimony about investigative procedure would amount to second guessing law enforcement officers. See Commonwealth's motion in limine. However, these cases are not applicable. Both cases dealt with in field arrests where officers had moments to determine the legality of an arrest. Here, there is no allegations that any steps police officers took were based on a fear of personal safety or immediate time pressure. Rather, the question is whether officers followed proper procedure and protocol in instances in which they had ample time to make decisions. While certainly officers in this case may have faced pressure based on weather and other considerations, this is very distinct from officers making heat of the moment decisions in a split second. The Commonwealth is free to present rebuttal testimony. During oral arguments, the Commonwealth repeatedly implied that admitting Mr. Easter's testimony would create some sort of slippery slope. The Commonwealth suggested that if Mr. Easter's testimony is admitted, that the Commonwealth would then bring in their own expert to rebut Mr. Easter's testimony. Go for it, buddy. Go for it. Do it, in Alan Jackson's voice. This is not true. Or that is true. Sorry, that is true. He can bring in his own expert. The Commonwealth is permitted to rebut a Bowdoin defense specifically by presenting evidence as to why the police did not follow the line of investigation suggested by the defendant. What the Commonwealth suggests would be impractical or impermissible consequence. Sorry, hold on. What? Start that sentence over again. What the Commonwealth suggests would be an impractical or impermissible consequence is actually an entirely expected result for a Bowdoin defense and is specifically supported by law. So, once again, Hank Brennan is going to strike out. He keeps losing. He keeps losing his motions in limine and what nots. He's lost plenty of motions here. Really, like, because he's really reaching for things, which is crazy. Mr. Easter's expert testimony is both relevant and admissible in support of a Bowdoin defense and therefore should be admitted for the above reasons. Ms. Reed respectfully requests that this honorable court allow Mr. Easter's expert testimony to be presented to the jury and then assigned by her attorneys. And then we have one final motion I'm going to read and then one more kind of announcement. So I know this was kind of a longer one, but there was a lot going on, and I'm sure we're going to get more motions and and more orders from Judge Canoni. Her decisions on some of these pending motions will be coming in, trickling in the next few days. Uh, as you know, jury impanelment starts on Tuesday of next week, so we're probably going to start getting, like I said, things are going to start trickling in more as if they haven't been already coming in super fast, and then we'll have more answers as to what's to come. So here's the defendant's motion requesting audio access to sidebar conferences during voir dire. So this came up in the most recent motion hearing where I believe it was just an oral argument. So this is now the filing for that. I believe Judge Canoni asked for it to be written up. So here now comes the defendant, Karen Reed, and respectfully moves this honorable court to grant her audio access to sidebar bench conferences throughout all critical stages of the proceedings, including individual juror voir dire. A criminal defendant is entitled to a trial by impartial jury pursuant to the Sixth Amendment to the United States Constitution and Article 12 of the Massachusetts Constitution Declaration of Rights. Per Massachusetts Superior Court Rule 6, the trial judge in each case has discretion to determine a procedure for examining and selecting jurors designed to maintain juror privacy and dignity, identify explicit and implicit bias, and foster efficiency in the session. A defendant's use of headphones at counsel table to participate in sidebar conferences, including juror voir dire, is an effective way to ensure participation in all critical stages, mitigate concerns that jurors will not feel comfortable answering questions honestly and openly in the presence of the defendant, and eliminate the risk of prejudice to the defendant. For the following reasons, Ms. Reed respectfully requests that this court exercise its discretion and grant her audio access to sidebar bench conferences throughout all critical stages of the proceedings, including individual juror voir dire. So when Alan Jackson was arguing this with Judge Canoni, she's like, well, Ms. Reed can just come up to the bench every time. But that looks clunky. It doesn't look right. I mean, yes, she can, but why can't you just give her a set of audio headphones and she can hear what's going on? They have them all over courts, all over the United States. So why would of course the Commonwealth just has to be different, and I'm sure they just don't have it. It was hard to hear with the microphone, and we had audio, hooked into the microphone. It was hard to hear. And people that were in the court said it was even harder for them to hear because they didn't hear that feed. So, I mean, most courtrooms usually have some kind of audio, headphones that you can hook in and listen to what's going on, especially for like victims or people who are hearing impaired if they wanted to hear what was going on. So why this is such an issue with Judge Canoni, I don't understand. Reed has the right to be present during all critical stages of the proceedings. Ms. Reed has the right to be present during all critical stages of the proceedings, including voir dire. Rule 18 of the Massachusetts Rules of Criminal Procedure provides the defendants shall be entitled to be present at all critical stages of the proceedings. The right to be present is derived from the Confrontation Clause of the Sixth Amendment to the United States Constitution, the Due Process Clause of the 14th Amendment to the United States Constitution, and Article 12 of the Massachusetts Declaration of Rights. Critical stages have been defined to include jury selection. It is improper to deny a defendant the privilege of being present at a voir dire if an appropriate request has been for his presence has been made. Ms. Reed's meaningful participation in voir dire is necessary for her right to a trial by an impartial jury. Ms. Reed's meaningful participation during the critical stages of the utmost is of the utmost importance to her right to a trial by an impartial jury. The lack of adequate voir dire may impair the defendant's right to exercise preemptory challenges. A defendant's presence when jurors are being examined and is necessary in order to aid counsel in the selection of jurors and exercise his preemptory challenges. The right to exercise preemptory challenges provided by Massachusetts Law 23429 has been called one of the most important of the rights secured to the accused. Ms. Reed is a member of the community in which she will be tried and might be sensitive to particular local prejudices which her attorneys may not readily identify. Noting the defendants have unique knowledge which is important at all stages of the trial, including voir dire, and may have knowledge of facts which may not have been disclosed to counsel prior to trial, but which may become important as the individual prejudices or inclinations of the jurors are revealed. So she might have some information that would be helpful to her attorneys to identify biases and things like that, things of that nature. Ms. Reed has remained thoroughly involved in her trial strategy throughout all prior proceedings, and it would be improper to deny her the privilege of being present for sidebar conversations during juror voir dires. Ms. Reed respectfully requests this court to afford her the chance to be present through the use of headphones at counsel table to enable her presence and secure her right to a trial by an impartial jury. Per Massachusetts Superior Court Criminal Rule 6, I'm assuming is what that says. The trial court in each case has discretion to determine a procedure for examining and selecting jurors designed to maintain juror privacy and dignity, identify explicit and implicit bias, and foster efficiency in the session. So a judge can apply discretion when she thinks, this it might be better for Karen to sit at her table with headphones than to be intrusive and standing over, listening over to the jurors and things like that. So it would be less intrusive if she were out of the way, had the headphones. Granting Ms. Reed access to sidebar conferences via headphones at counsel table is within the court's discretion. So she should be able to do it, and we'll see. Granting Ms. Reed audio access to sidebar conferences at counsel table during voir dire is within the court's discretion and will allow her to meaningfully participate in identifying implicit and explicit bias among potential jurors. Additionally, limiting the number of individuals crowding the bench during sidebar conferences will foster efficiency during the voir dire process. Ms. Reed's meaningful participation in the voir dire process can be facilitated by the use of headphones at counsel table. Avoiding overcrowding of sidebar conferences is an important logistical consideration for both efficiency purposes and ensuring jurors feel more comfortable answering honestly. And that is signed by her attorneys. And finally, I saved the best for last. I think this is the best for last. So we just got an appearance filed by a Victoria Brophy George Esquire, who, as you can see, is with the Unetti Criminal Defense Law Firm. Okay. It says appearance of counsel. Please enter my appearance as counsel for Ms. Reed, the defendant, in the above entitled action. Something just spooked my dog. I don't know what it was. So this woman Victoria. Let me switch screens here. So we're just a little bit shy of a week away from Karen Reed's second trial. So today we're 5 days away. This was 6 days when I posted this. So we're 5 days away from Karen Reed's jury impanelment to begin. And newly added to the docket yesterday morning is an appearance to represent Karen in trial 2.0 by a Victoria B. George Esquire. Ms. George actually served as a juror in Reed's first trial and was inexplicably made an alternate juror, which excluded her from deliberation. So she did not deliberate, and she was, if you recall, on that like last day when they selected the alternates, they chose her name in the twirly thing in the spinny thing. They had supposedly they had the numbers of all of the jurors in there, but we don't know because nobody saw it and nobody ever confirmed it. And they called out the numbers of two of the jurors, both of whom were more pro Karen Reed by the looks on their faces throughout testimony, and they were moved to uh, be alternates, while the person sitting in seat one, juror one, just got to be jury foreman without any um without any without any question. She just selected him. So there's some very fishy things I think that went on that day. Ms. George, so she served as a juror. She actually, after the mistrial, she spoke anonymously with Aiden Turtleboy Carney about her experiences on the jury. You can read the interview here. So there was I'll link that down below in the description so you can go back and look at her interview. She was anonymous at the time. Now we know she's been publicly on the record, and she spoke with WBZ's Christina Rex after a heated hearing where the defense argued their motion to dismiss. Um, I think that was back on the 5th, I want to say, March 5th, when they argued their motion to dismiss, and Hanky was quite unruly that day. So this individual, the juror, who we now know as Victoria George, came forward and said this. I was a fair minded juror who left this trial questioning the integrity of the system long before the defense filed a motion to dismiss with allegations of jury tampering. It is the Reed case itself and the fact that it is still being brought that has left many in Massachusetts wary, distrustful, and scared of our system. As a lawyer, this reality saddens me even more because I remember how much faith I had in our system as an optimistic law student. Mr. Brennan made an impassioned argument today regarding his alleged concern that some might be questioning the fabric of our entire system. If he truly would like to address that problem, I have a few suggestions. Perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systemic issues plaguing it and affiliated police departments rather than continuing to spend more millions of tax dollars prosecuting a case with so many evidentiary issues that it calls into question whether they are even following their ethical obligations as prosecutors. I mean, she came out blazing. The Commonwealth has a duty to protect the rights of defendants, and I, for one, would love to see them do that. That, my friends, is a beautiful quote. I follow that up by saying, and to put the cherry on top of this beautiful Sunday, Ms. George is a Massachusetts attorney, and corrupt Canoni has no authority to deny or remove her. Pro hoc vice status is not required. This is a brilliant move by the defense. Tick, tick, boom. We are we are gearing up. I think this is a brilliant, brilliant move by the defense to bring on the juror. What better insight are they going to have about jury's thoughts? I mean, granted, she was not in the deliberations themselves, but she was a juror. She sat there and watched all of the evidence unfold, as many of you did at home too. And she realized something was fishy. And now she's on the side of justice and she's fighting for Karen and for justice for Karen, which is just, this never happens. This is incredible. This is mind blowing. This is insane. I love that this happened for Karen, that they were able to get her. People now are like saying, "What wouldn't it be amazing if Josh Levy, the former acting AG, came forward and decided to represent her?" I think that would be so hilarious. I don't think that's going to happen, but that would be such a good call. Such a great moment in time. And you could really see Judge Bev and Hank shaking in their boots if they had Josh Levy coming in and defending Karen Reed too. It's just all insane. I don't even know what questions to ask you after all that. Where to begin? So you guys let me know what you think of all of that. I know we went through a lot. There's still, I'm sure, more that we will have to get through in the coming days just to kind of stay caught up because I'm sure info is going to be fast approaching, and with impanelment and jury or trial heading towards us very shortly, it's going to get here fast. So we're going to have lots to cover. So let me know what you guys think about this case, and I will see you guys in the next one. Take care. Please don't forget to hit that like button. Bye now.